to introduce tonight's guest speaker. My name is Paul Gannon. I'm a professor of chemical and biological engineering here at Montana State University, and it's my pleasure, my honor to introduce my good friend, Giles Turner. Giles, you wave your hand so you know which one you are. Fantastic. So Giles and I graduated near about the same time in chemical engineering from Montana State University in about 2003. Giles went on to an illustrative career with Micron first before he kind of switched career trajectories and went to University of New Hampshire, a prestigious law school called the Franklin Pierce Law School, where he studied, among other things, patent law. He then became employed as a patent attorney, which has brought him to his present path today. Not only is he a good friend, he's also what I would say a proficient skier and also a decent whitewater kayaker, and a good human being as well. And so please join me in welcoming Mr. Giles Turner to this forum. All you, Giles, take her away.
I want to thank Abby and Paul for inviting me. This is a real honor to be able to speak to the Chemical Engineering Department at Montana State. I've had an interesting career path. Like Paul said, I started out at Micron Technology and working in semiconductor processing, and then went on to law school and studied and focused on intellectual property during law school, and with a particular focus on patent law, being my intent to become a patent attorney. And after law school, I found a job in Washington, D.C. with a firm that does a lot of semiconductor processing and different materials applications, oil field technology, exploration. So very useful to have a background in chemical engineering and to have some work experience in the semiconductor field. I worked, I guess, about 5 years in the first firm I joined, and then that firm merged into another firm, and I've been with that firm since then. So I've been practicing just over 10 and a half years. And my practice is focused in, the area of patent law for attorneys is fairly broad. There's lots of different focuses. There's litigation, which attorneys that deal with contested matters between parties over alleged infringement of patents. There's also prosecution, which is the area I work in, and counseling, primarily focuses on procuring, drafting patent applications, procuring patents, and then rendering opinions on patents, issued patents, or pending applications. And we'll cover a lot of that in detail, or some detail today. And then there's also other areas like licensing of patents, contractual agreements between parties. That's a big area, especially in corporate law departments. There's also patent prosecutors often work either in the corporate side or in the law firm side. I personally work in the law firm side, but yeah, there's lots of different avenues to go about this. A lot of attorneys also work for the federal government. In the solicitor's office of the U.S. Patent and Trademarks Office, or as actual patent examiners. A lot of my colleagues, before they became patent attorneys, were actually examiners at the U.S. Patent and Trademark Office, and then went to law school while working there. There's also other avenues, such as becoming a patent agent. You do not have to have a law degree to become a patent agent. You can draft and prosecute applications based with just that certification that's issued by the U.S. Patent and Trademark Office. So with that general overview, I'll get started with, I have a brief PowerPoint presentation that kind of quickly covers 30,000 foot view of patent prosecution and opinion drafting. So here we start with the first page. It says, what is a patent? What what kind of attorney would I be if I didn't give a disclaimer? So my presentation today is not to be construed as me providing legal advice. I'm just providing opinions on my career path. So
is this pardon me, can I interrupt you for a second? Are you showing the PowerPoint?
Yes.
Okay, it's not coming through on our screen.
Okay, let's back up. Did I miss something? Okay, share screen. Okay, can you see that?
We
All
can.
right, great.
Thank you.
All right. Oop. So in the United States, there's basically 4 common types of intellectual property. First being the presentation today is going to focus on patent protection, which protects inventions. Patent protection is a kind of a trade-off with the federal government. In order to get exclusivity, protection for your invention for a limited time, you have to disclose your invention to the public and provide explanation on how to practice it, make it, conduct it, etc. Patents are generally considered a return on investment for research and development. And patents can be extremely valuable or have very little value. It just depends on the market for the invention that's covered by the claims of the patent. Also, another type of intellectual property that's very important in the United States is trade secrets. It protects information that is not publicly known. There are high-profile cases dealing with trade secrets, but a lot of times have to do with basically an employee of one company leaving and going and joining another company and taking secrets from his former employee to the new company. And if there's any kind of misappropriation in that transfer, you'll often see litigation in this area. Trade secrets require strict maintenance of secrecy by contract and security policies and actual physical protection of the secrets through security measures, guarded files, and whatnot, encryption. Also, there's trademark protection. This is identifies sources such as goods and services, and the intent of trademark is to protect the consumer against confusion. Trademarks can also be extremely valuable to prevent counterfeit marks being used to sell goods. And I'm sure that you've heard of cases like this that arise in the United States and overseas. The 4th common type of intellectual property is copyright protection. So generally, patents and trademarks cover ideas or representations of goods and services. Patents covering inventions, but copyright is special in the fact that it's not the underlying idea itself, it's the expression. So copyrights basically cover anything from literature, written matter, music, sculptures, videos. As long as it's fixed in a tangible medium, it automatically obtains copyright protection. You can also register with the U.S. Copyright Office and get special protections by doing that. So what is a patent specifically? There is some confusion in the public about the nature of a patent. So a patent is basically a special type of document that includes claims that define the scope of rights that protect an invention. And those claims are basically the right to exclude other parties from making, using, selling, offering for sale, or importing the claimed subject matter. Patents do not confer a positive or affirmative right to make, use, sell, etc., an invention. It's just the right to exclude, and that's, if anything, today that I provide as information. These are probably the two most important points, just a general understanding of patents. So, since it's not an affirmative right to make, use, or sell or import an invention, the concept here is that there could be other patents out there that are actually broader in scope than what you claim in your patent. So you may actually infringe someone else's patent if you make a product, even though you have a patent covering your product. There could be something broader in the art, in the issue patent, that would cover your purported product. So it's an important distinction to understand. So how does it all start? So, I mean, generally I kind of view the approach to conception of an invention in some different ways. Usually people approach things from a problem. They see a problem in their lives or in a certain area of technology, and they come up with a solution, and that solution can become an invention. There is also probably the most common area that I see is improvement on existing technology. Additions to or modifications that provide significant improvements over existing technology. That's, I think, the bulk of patents cover that type of progress. There's also, occasionally you have a pioneering piece of technology, which is, if you obtain a patent, can be extremely, extremely valuable. I actually work with some guys that were associated with obtaining patents covering email by telephone, and those patents proved to be extremely valuable commercially. So there's different ways to basically conceive of an invention. So once you have this conception, whether or not you actually make a device or practice it, once you have the idea of your invention, you can have a search conducted. It's optional. It's not required by law, but it's recommended before you enter the process of trying to obtain a patent, because it gives you kind of a lay of the land of what's out there. You may be aware of a lot of what we call art or previous technology related to your invention, but it's also good to see kind of what the patent office might become aware of during the prosecution process. Prosecution, again, being the procedure of obtaining, preparing, filing, and obtaining patent rights. Filing being a patent application. So this search at the preliminary stages can be conducted professionally by a search firm or a law firm, or you can do it yourself. You can look online. There's a large number of resources: Google Patents, Google Scholar. The USPTO has an in-depth search engine for looking at the issued patents, previously issued patents, and pending applications and published applications. Those are all very helpful resources for searching to see what exists in the art and what may be applied to reject claims during prosecution of a patent application. So when you basically, after you have that idea, then you're going to, an applicant or inventor is going to contact someone that can draft an application, or they can even attempt to draft it themselves, but it's probably not recommended to do that just because there's lots of pitfalls in patent protection and applying for patents. So basically, you're going to draft an application that includes 3 or 4 specific parts. The first part being a specification, which describes that fully describes the invention, how to practice it, how to make it, how to use it, the properties of the invention, and then you have claims. And claims are basically what is generally argued the most during prosecution. Claims are the scope of protection, the right to exclude others that you would obtain in a issued patent. So if you're looking at a claim, it's basically a long sentence that describes with specific detail the nature of the invention. During prosecution, those claims can be amended to become broader or narrower. And it's kind of like arguing about how big your piece of land is. That's a good way to look at it. Your land being the piece of property that you can exclude other people from walking on. So then the application also includes like a brief paragraph just summarizing the invention that would be in the abstract. And then depending on the nature of the invention, especially mechanical devices, you're going to have illustrations. A lot of chemical cases, not so much, especially for just pure compositions or processes. There may be minimal illustrations, only when necessary to fully describe the claim subject matter. There's also a number of formality documents that are filed with a patent application, being inventor's declarations, basically a statement under oath regarding this is my invention. It's not somebody else's, or I'm a joint inventor for this inventor along with these other people. It was made by me, and acknowledging a duty to disclose information to the patent office. You have to be very honest and forthright with the patent office during prosecution, or else if you're found later in litigation to have hidden some art that you're aware of, or conducted any kind of impropriety or been dishonest during prosecution, it can render a patent unenforceable. So all these things, those kind of statements are in the formality documents. So about roughly 18 months after filing your application, it will be published by the patent office unless you file an express request not to publish. The publication is a requirement for under international treaty between countries. So if you request not to publish in the United States, you're not supposed to file overseas unless you rescind that request not to publish. So here you see just this is a dog chew toy publication. This is the first page. You see one of the drawings from the application, and you see the abstract there. And this is just the first page of the published application. This is actually a patent, but basically the number is longer for a publication instead of just the 7 or 8 digit patent number. You'd have a much longer publication number at the top of the document, and it would just be a publication. It doesn't confer any positive rights to the applicant. So about a year after filing, it may be before publication or after. It varies really depending on the technology at issue. In a patent application, you'll receive what's called an office action. And you don't want to, it's generally not good to obtain an allowance or obtain a patent without any type of office action out the gates, because basically that means you've claimed your invention too narrowly. You want to be in a circumstance where generally your claims are broad, so that your protection is broad. Your right to exclude is broad. And then when you get a rejection, then you can amend the claims to avoid certain pieces of prior art or other issues raised by the examiner. The office action can include formality rejections to make you correct the drawings or specific language in the claims. It's not necessarily a substantive issue with regard to the scope of protection. Then you may have subject matter rejections based on the nature of what you're claiming. You can also have, like I've mentioned, prior art rejections based on scientific publications, prior patents prior published applications, like I mentioned in the previous slide, can be applied against your patent claims depending on the priority date that you claim. So generally, stuff that's been publicly known before your priority date can be applied against your filing. Your original filing date can be applied against your claims. So I mentioned just a minute ago that you could have rejection based on subject matter. So there's several different types of U.S. patents. There's utility patents, design patents, which cover ornamental designs, and there's plant patents for distinctive new asexually reproduced plants. But today the focus is going to be on just utility patents. They're the most common. So basically, there's basically 4 statutory classes of utility that you can pursue for a utility patent. First being processes. As chemical engineering students, I'm sure that you're aware of many different processes in the art and possible improvements that you could potentially obtain a patent for. Machines are very commonly patented as well, any type of device. An article of manufacture, something like, an example would be a crowbar, very crude example, but a crowbar is an article of manufacture. A composition of matter. So this for me is the very important field that I practice in the most. Processes and compositions of matter. Composition of matter being materials, composites, adhesives, inorganic materials that are new and useful. So, however, there are some exceptions to patent eligible subject matter, and those rejections in your office action can be basically if you claim something so broadly that your claim encompasses an abstract idea, a law of nature, or a natural phenomena such as a product of nature. The examiner may reject your claim because those are what we call judicial exceptions. They've been formed by judicial opinion. They're exceptions to patent eligible subject matter. So abstract ideas come into play a great deal in the area of software, and when trying to patent software or telecommunications systems, or even business processes. These types of rejections can be raised on abstract idea. Laws of nature and natural phenomena can come into play, particularly in the biotech space, and also abstract ideas in the diagnostics for different types of diseases, and also genetic material. Usually a genetic material, there's been even a Supreme Court case regarding modified DNA versus natural DNA, isolated natural DNA not being patentable, but modified DNA being patentable. Then some other requirements under the statutes, patent statute, upon which your claims can be rejected are definiteness, which is basically the clarity with which you claim your invention. If your claims are very vague and ambiguous, and to the point where someone would have trouble determining whether their product actually infringes your claim, then basically the patent office is going to reject your claim based on indefiniteness. It's not being definite, the language not being clear. There's also other requirements for adequate written description. So in your specification, like I mentioned earlier, it's as part of the application that accompanies the claims. The specification must fully describe what you claim. So if you want to amend your claims during prosecution after an office action, your specification has to provide full support for what you're claiming with the amended subject matter. And that can be express or implicit within the specification. And then another requirement for the specification is that it must enable those skilled in the art to practice and make your invention. So you generally can't hide some critical part of your invention from the public. You must fully disclose how to make and use and practice the invention, or else your claims can be rejected as not being enabled by the description and the specification. So then art-based rejections can be based on anticipation, which is basically a single piece of art discloses all of your invention, either expressly or inherently discloses your entire invention. This is a common type of rejection. And then another type of rejection is what's called obviousness type rejection. That can be one or more references, either alone or combined together, would provide those of ordinary skill in the art reason to make your invention. So this is, I'd say this last point of obviousness is where most patent prosecutors spend their time, is arguing that a claimed invention is not obvious over the prior art. Usually it's not a super difficult threshold to meet, novelty or lack of anticipation, but obviousness can be a more difficult battle. So I pretty much covered, oh, go ahead. Paul, do you have a question?
Yeah, I was just going to stop you real briefly. A slide or two ago, there was a student that posted a chat question, and I just want to make sure that you cover that in advance of going on.
I didn't see it.
No worries, no worries. I'll just read it for you. It's, why would somebody request that their application not be published?
That's a very good question. So, you know, I presently work with a client that has a new composition. They don't want to be publicly known unless they obtain a patent. They don't want it to be published because somebody could copy it. If they don't end up obtaining a patent in the long run, if their application is published, somebody else can make their product. And if my client doesn't obtain a patent, then that person can compete with them in the marketplace.
Cool, thanks, Giles. I'll just let you know if I see other ones pop up.
Okay, yeah.
All right, proceed.
All right, so I kind of already covered some of this. So this is the response to the first office action, where you can either, without amendment, you can argue against the examiner's objections or rejections. You can submit evidence in the form of declarations signed by experts. A lot of times I file declarations that include scientific experiments that demonstrate that the prior art doesn't possess a property that I'm claiming of a composition of matter, or that my claimed invention is actually superior in some type of performance over the prior art. You can also, with a response to an office action, amend the claims. Like I mentioned, you can broaden the scope, you can narrow the scope. Most amendments are generally narrowing or clarifying scope of invention of the claim recited in the claims. So once an office action issues, you have 3 months to respond, and that can be extended for another 3 months to a total of 6 months. You can also call the patent examiner that issued the office action and talk about the rejections over the phone, or you can visit the patent office and talk with the examiner there about the rejections. And sometimes you can negotiate with the examiner as to the scope of the claims that would overcome the art, or you can explain how the examiner maybe most often does not understand what you've claimed, doesn't understand the invention and how it's different. You can often involve inventors in these interviews. You can take an inventor to the patent office with you, or they can join you on the telephone and speaking with the examiner. If you go in person, you can take samples. If it's a product, or if it's a machine, you can take a sample of the product or a prototype of a device and show the examiner. And a lot of times that will help the examiner understand the invention. Examiners very pressed for time. They have very short amount of time to review applications, and issue office actions. So anytime you can make their job easier by explaining things, or providing something they can look at in real life, it helps them. So after you file a response to an office action, you can receive another non-final office action. However, in the next slide, typically after the first office action, you get what's called, after you file a response to the first office action, you receive what's called a final office action. And this doesn't mean the end of the road for the applicant. This is just basically a procedural tool that forces the applicant to choose how to proceed. So the process doesn't go on indefinitely. So there's basically three options when you receive a final rejection. Usually the final rejection is going to include either a rejection based on subject matter, which you're falling within one of the exceptions, judicial exceptions to patentable subject matter, or you have art-based rejections like anticipation or obviousness rejections that you have not overcome yet. So at this stage, applicants can quit, just give up. They can abandon an application, just not respond to the final office action. Again, you have that same period for response, 3 months, and then it can be extended for another 3 months, so a total of 6 months. You can also file a response after final office action in which you argue or amend the claims to see if the examiner will agree with you. Sometimes you can even persuade the examiner to conduct another interview with you. After an application has been twice rejected, so 2 office actions, whether the last one is final or not, you can file an ex parte appeal, which is one party proceeding against the patent office before the Patent Trial and Appeal Board to contest the examiner's rejections. So I'll just go through some flow charts that kind of illustrate a little bit of that process. So I mentioned filing an after final amendment. You can file that and submit it to the examiner and see what they think. And maybe possibly that they'll find your amendment to be allowable and give you a call and say, hey, listen, if we tweak these claims a little bit, this application will be allowable. But more often than not, if you file an after final amendment, the examiner is just going to send you what's called an advisory action saying, this is going to require too much time for me to consider. You need to file a request for continued examination. That's basically, it's just a simple form, but a lot of money to restart the process. And an RCE can be filed at any stage of the prosecution to restart for any number of procedural reasons. But if you get an advisory action, you're generally going to have to file a request for a continued examination to get the examiner to again look at your claims and issue another non-final office action. Also, another important point to consider in this process is that at any point after filing your initial application, you can file what's called a continuation application. So this is an application that claims the priority of your first application, but includes different claims. So it can be the same general type of invention you're claiming, or it can be a different type of invention that's still supported in the original specification. A lot of times these type of applications are forced by the patent office if your application is long enough to include several different classes of inventions, process, and composition of matter. The examiner may require you to file separate applications based on the different types of claims, a method of making or the actual product. But these continuing applications can be filed at any time as long as the original application or the application at issue is still pending. It hasn't issued or hasn't been abandoned. And you can keep, this is a very useful tool for patent applicants, because even if you obtain a patent, if before that patent issues, you file a continuation application, you can keep an application pending, and it can make your competitors guess as to what scope you're going to try to claim next. And it can dissuade them from trying to compete with you in an area close to your invention. Oh, wrong way. So I mentioned appealing to the patent trial and appeal board. If you have an application that's been twice rejected, you can file a notice of appeal to go up before what we call the brief the board, or the PTAB, the Patent Trial and Appeal Board. Along with the notice of appeal, you can optionally file a pre-appeal brief request for review. It's basically a 5-page brief, including very concise arguments why the examiner has committed errors in her rejections. And a panel of 3 examiners reviews this request. And if they find that the examiner has clearly committed errors and there's no issues remaining, they can either kick the appeal back to the examiner and make the examiner either allow the application or make the examiner issue different rejections. This is a very useful tool if the examiner is not spending enough time to understand the claimed invention, or if they're misinterpreting the prior art. Also, if at any time, after you file a notice of appeal, you want to go back to prosecution, you don't want to proceed on appeal, you can also follow that document I said was called an RCE to start over. You don't have to proceed. You can back out of appeal at any time. So what happens if you don't file a pre-appeal brief request for review, or the panel of examiners said, well, there are issues remaining, you need to proceed on appeal, then you file after you have a period of 2 months to file from the notice of appeal to file an appeal brief. And this appeal brief is going to include basically a chart of your claims, explaining support in the specification for every claimed element, and it's going to have detailed arguments why the examiner's rejections are erroneous. And you're going to request that the board reverse the examiner's rejections. And hopefully, as I'll show you in the next slide, if you file the appeal brief, then the examiner, sometimes when you file an appeal brief, it's like calling the examiner's bluff, and they'll back out and send it back, and they either allow the case or modify their rejections. This is a little bit frustrating sometimes, because if you file a notice of appeal, you want to get resolution by a third party, not the examiner, but they can back out and issue a new rejection or allow the case, which would be good news. But more often than not, after you file an appeal brief, you get what's called an examiner's answer, which is the examiner's counter argument to your appeal brief. And it's basically just recasting the examiner's previous arguments and answering any type of new argument that you raise in your brief. And after you receive the examiner's answer, you have a short period of time with which to file a reply brief to the examiner's answer. And this reply brief is also it's shorter than the appeal brief typically, and it's a reply to the examiner's answer and his contentions and his arguments. At the time of filing the reply brief, you can optionally file a request for oral hearing. You can go and actually argue before a panel of judges at the patent office in person or via teleconference. Especially these days, a teleconference is more common. The oral hearing is optional, though. You can just argue on the briefs and there can be no hearing at all, and the board will decide the case. For really important cases, it's typically good to have an oral hearing to explain your invention and the advantages and allow the judges to answer any questions. It looks like I have. Is there?
No, I don't see anything posted right now, Giles.
Okay.
I just, wondered if there were any questions on this so far. There's some great detailed explanations on the patent process. And I don't want to derail you at all. I was just curious.
We're about to get out of the weeds. I promise.
I think some students are fascinated about your career trajectory. So once you get out of the weeds with the patent stuff, then you can cover that jazz.
All right. So if you win, it can go back to the examiner. If the board decides it's in your favor, and the examiner can issue an allowance or issue new rejections. If you lose, you can petition for a rehearing by the board, or you can take it to federal court and argue it in either the Court of Appeals for the Federal Circuit or in district court to contest the Patent Trial and Appeal Board's opinion. You can also, like I said, file an RCE and restart prosecution if you lose. You can file an RCE at any time. So once you receive the positive notice of allowance saying your claims are allowable over the prior art and all rejections have been withdrawn, then you have a short period of time, 3 months, to pay the issue fee to the patent office, and then the patent issues. The issued patent then must be maintained. The fees are due to maintain the patent without expiration are due at 3.5, 7.5, and 11.5 years. And you can also, if you find out if you have an issued patent that you have errors in your claims, you can seek broader protection by filing a reissue application. Or if there's other errors to clarify the scope of your invention, you can also file a reissue application. So any issued patent is subject to challenge, either in federal court or before the Patent Trial and Appeal Board in either what's called a post-grant review proceeding or an inter partes review. So say a third party wants to contest the validity of your patent, they'll do so before the PTAB or in federal court. So shifting gears a little bit out of prosecution, I mentioned opinions earlier. So again, I said that very important distinction about a patent is it's not a grant of affirmative rights to make, use, or sell your invention. There may be other patents out there that are broader than the claims in your patent, and that could still cover your invention. So even if you're going to make it, you want to obtain some type of opinion to make sure that you're free and clear for not infringing. So this would be an FTO opinion. Basically, your attorney is going to review, conduct a search of the existing patents and applications, see what the claims state in those patents and applications, and determine whether your product would infringe. It's also focused on usually a typical country like the United States. Of course, for a U.S. attorney would conduct this on U.S. patents versus Europe or China or Japan. You'd usually have a local counsel in one of those countries conduct this type of opinion. So you get this to basically try to avoid litigation and threat of an injunction issued by a court preventing you from making or selling your invention. It avoids disruption of business caused by litigation. So some other types of opinions, non-infringement. So if you find a piece of prior art, you might want to have an attorney look at that and determine that your product actually doesn't infringe the claims of that issued patent, and that can protect you down the road. For instance, in court, you can produce this opinion and say, "Oh, I didn't willfully infringe somebody else's patent," because willful infringement can be up to 3 times the amount of damages in an infringement suit. Invalidity opinion. So say you find somebody's issued patent that has claims that you think your product falls within the scope of. You can challenge those issued claims based on those grounds that I discussed earlier on statutory grounds for invalidity based on indefiniteness, anticipation, obviousness, and non-statutory subject matter. So now we're free to answer any questions that you have, and I hope that gave you a general idea of what a patent practitioner, patent prosecutor's life is like. So feel free to ask any questions.
Thanks, Giles.
I certainly have one that came from a student, Sam, if we can start with that. One of the questions Sam asks is, how did a chemical engineer get involved in patent law?
Well, basically, there was a professor when I was in MSU, in the chemical engineering department, that talked about a previous graduate that had become a patent attorney and talking about his career path, and it interested me. Also, I've done some hands-on work in a chemistry lab, and I've worked in a manufacturing capacity, and I tend to be a clumsy guy. And I've been in a couple of different fires, and I'm better with books and reading and analyzing than I am with actually making things. And so it's the perfect fit for me is to it's like, I think my job is most like trying to figure out a puzzle. So if you like figuring things out by reading literature and the learning process and reviewing different types of technology in written subject matter, I think patent law would be a good fit. If you, on the other hand, like to be hands-on and making things and running equipment and help optimizing processes, I think maybe patent law might be a little bit boring, but it just depends on your kind of personality and what interests you.
Excellent. We have a question from the chat. I believe it came in via chat, asking, what is law school like? Was it difficult to go back to school after working for a little while?
It was difficult to shift back to that. It's a law school is fairly intense. It's you have a lot of competitive personalities. Law school will rank every student in a class, and everybody's competing for the top spots to get the best jobs. And that's from the very beginning, even the very first year of law school, it's highly competitive. And if you've taken a break and worked, you may not be used to the amount of rigorous study that it takes. But that being said, I think there are some positives to going out into the field and actually getting some work experience before you go to law school. Like I mentioned before, I worked at Micron. I didn't work there very long, but I did work there for long enough to get some experience in semiconductor processing that actually landed me my first job, because that firm handled clients that worked in that filed applications in that technology area. Also, if you're interested in becoming a patent attorney, there are alternatives to going straight to law school that might actually give you some exposure to the actual working life of being a patent attorney, or what you would be typically doing. There's different paths, like I mentioned, the patent agent. You can take the patent bar exam if you have a technical degree. You can become a patent agent and work for a law firm or a corporation in their patent department. You can also apply to work for the actual patent office as an examiner. They hire regularly different types of examiners, and that's invaluable experience for exposure to how patent prosecution works. If you're interested in becoming a prosecutor, those are both very helpful. Even many former patent examiners will become litigators. They will get their basic experience as examiners, and then will later move on, go to law school, and then begin litigating patents. There's lots of different avenues to take.
You touched upon this a little bit, but specifically, what aspects of law school were the most challenging?
The most challenging for me at first was focusing on issues, the biggest issues and the alternatives. Like being an engineer, you have very good analysis skills, but you're always looking for an answer. And with the law, there's generally multiple answers and multiple alternatives and competing conclusions that you have to analyze and work your way through. And typically you have one exam for an entire semester, and you have to sit and write an essay based on a fact pattern applying the law, and you have to perform that analysis within an hour in that exam, and that can be very challenging. You have to fully understand the law, but then there's also an important skill of how to perform that analysis, examining the alternatives, why alternative A would be less persuasive than alternative B, and why you would go with alternative B for your conclusion, instead of just like, here's the answer. That won't work. So.
And this is a question I've just wondered. I've heard the patent bar is more challenging than the regular bar. Was that your experience? And how, if you were going for both, how do they set you up to take those? Which do you take first? How does that work?
There's no required order to taking, if you want to become a patent attorney, there's no required order. Of course, you can't become a patent attorney without taking a prosecutor, without taking the patent bar, but you could become a litigator without taking the patent bar. But in order to prosecute patents, you have to take the patent bar. I took the patent bar about 6 months before I took a state bar. The first state bar I took was in Idaho. And the patent bar, I personally don't think it's as difficult as the state bar. The state bar covers much more material. The state bar covers multiple areas of law, not just property law, not just intellectual property law, not just patent procedures. So the patent bar focuses on patent law and procedure, and it's based on a manual that's published by the U.S. Patent and Trademark Office. And it's also an open book exam, or at least it was when I took it. So so as long as you understand how to make your way through what's called the Manual of Patent Examining Procedure, it's roughly 3,000 pages. During the exam, you can pass that exam no problem. But some people do find the patent bar to be more challenging. Personally, I found the state bar to be more daunting. It was 3 days of examination, whereas the patent bar was, I think, 3 hours. So much more, and the state bar is all by memory. You have to memorize all the areas of law and write those essays. Write essays for each type of fact pattern that's presented during the state bar. And the patent bar exam is a multiple choice exam, which the answer is in front of you. You just have to find it. So,
I've got a question, Giles. You graduated in 2003, which is a bit ago, from Montana State University in chemical engineering, and you've had a illustrative career since then. Looking back on it, what, if anything, would you explain to your former self when you were a student in chemical engineering at MSU? What do you wish you would have known then, what you do now, so to speak, professionally speaking?
Having been looking at becoming a patent attorney, if I am a prosecutor specifically, I wish that I'd continued on and got a doctorate in one of the hard sciences, like chemistry, biochemistry, or any type of PhD. Even a PhD in chemical engineering is very valuable to many firms. It's just an added layer of credentials and understanding of sophistication. So, I mean, as far as getting jobs, I think PhDs probably have the easiest go of it. They're in high demand whenever you look at job postings for patent prosecution positions. They're generally, a lot of times, especially with chemistry, they're going to require a PhD or at least a master's.
So continuing education would be your suggestion to your former self?
Yeah, I think so. Also, I would not have regretted going to work for the patent office initially, to get some experience in the patent area before actually going to law school. Also, that would prime you for reading and understanding patents, and also just generally for law school, performing the legal analysis. Becoming a patent examiner would really condition you well to enter law school. And more than a decade ago, I don't know if they still do, but the patent office used to pay for examiners to go to law school. So that is a huge plus, because law school can be very expensive, especially if you're paying out of state tuition or going to a private school. So I think becoming an examiner, or you could work in a law firm too. You could work in a law firm part-time while you're in engineering school. That'll give you experience with analysis and legal analysis and research.
We have a question from a student, Sam. Do you yourself have intellectual property?
I do not. Well, I have some domain names, but I don't have any issued patents. No, I wish I did. I have ideas that I've been sitting on that I should probably try to obtain a patent, but I work too much.
We won't ask you about the domain names. This has been really helpful, Giles. I really appreciate your time. Certainly an opportunity for students to ask any other questions of a former chemical engineering student, and appreciate you reflecting on your past as a student here. And yeah, I'll open it up, of course, to anybody. No holds barred with this guy. I've got a question in the chat here that I'll read. And you could read it too. It seems like patent law rides a fine line between protecting and monopolizing IP, intellectual property. More specifically, patents surrounding biotechnology appear to be potentially threatening scientific innovation. Do you believe that some companies abuse patents in this way? And if so, where do you draw the line?
That's a great question. It's one that's haunted patent law since its inception. Is the fight. It becomes an antitrust issue. There can certainly be abusive patenting of technology, but based on my experience, a patent is only for a limited time, and it's 20 years from the date of filing the application. And also, I personally think that patent obtaining and disclosing inventions versus maintaining them in secret actually spurs more innovation. It's going to incentivize people to create more, to work around your patent, to find different solutions. Of course, you're going to have exclusivity for that limited time, and in a way is like monopolizing that particular piece of technology, but eventually that will all be public. The patent will expire, and in the meantime, people can work around it and develop new technologies in the process.
All right, we have another question that came in, and they asked, are you glad you went into the workforce, even if it wasn't in the patent office, before going back to law school? And did you get a job straight out of undergrad?
So when I didn't focus too much on internships when I was in engineering school, I was a raft guide during the summer. So I kind of shot myself in the foot. I didn't have a job right out of engineering school. It took me about 6 months after I graduated to find my first job. I don't regret going out into the workforce. I think that especially if you can get some type of technical experience, I think that's highly beneficial if you want to become a patent attorney. If you want to become another type of attorney, I would recommend going to work for a law firm or even a legal department of a corporation. I don't regret going into the workforce. I think it would have been easy to go straight into law school. I would have been used to the rigors of studying, and it wouldn't have been such a jolt going back. But I don't see any disadvantage really to taking time to get some experience before you go back to school.
One logistical question for you. You put up your email address and phone number. If students were going to contact you, I've already taken that down, but students I'm sure may have taken note of it. What's your preferred form of contact? Do you prefer
either way, email or telephone? I can put that back up if you want me to.
I've already changed off of you as host. So,
okay.
It's on the video. They can go back and access it. We'll have it back up on AICHE's webpage. We'll have the video up probably sometime tomorrow or the next day. so that students are able to access if they didn't happen to jot that down. And students, if you have any questions before we wrap up, now's the time. Paul, did you have any other thoughts or questions?
No, just general appreciation for an alumni to share their career trajectory with us and the students, and what an opportunity for the students to have a dialogue with alumni. So appreciative of Giles taking the time to do this. His time is very valuable as a patent attorney. He could talk separately about that, but the things that motivate us and how we get to where we're at as professionals, I think it's fascinating for students to see all the various pathways, and Giles is a perfect exemplar of what could be as a MSU graduate.
I appreciate the opportunity. It was my pleasure.
Yeah, absolutely. Thank you very much. Austin, if you can put back up the information. Again, thank you on behalf of the students, MSU's AICHE chapter, all the faculty. This is incredibly informative, and a lot of people aren't able to do this in a synchronous fashion, but we're having a lot of students access these videos after as well, and we had a good turnout tonight for this. So once again, thank you very much. It looks like we may have had one more question. No, just a thank you come in from Cade, and Talis also sent her thank you as well. So thank you very much. It's been an absolute phenomenal pleasure, as Dr. Gannon mentioned, having you here. What a wonderful opportunity for our students. Thank you very much.
Oh, you're welcome.
Thanks, Giles.
Well, now.